Well, hello everyone. Welcome to the Mid Speeds live class. Let's go ahead and get started with some common words. Here we go. Ready? Heed, grab, she's, kind, decide, follow, realize, reach, care, phone, stay, notice, best, without, car, show, inside, suddenly, father, rest, herself, grin, hour, hope, also, body, tonight, might, hadn't, floor, it's, continue, ran, across, hold, cry, half, pretty, great, course, mouth, class, kid, miss, wonder, morning, least, nice, dark, slowly, done, doesn't, together, yet, change, question, anyway, bad, blue, believe, weak, God, lip, Mr., sleep, fine. All right. Common phrases that we often hear, so you're going to phrase as much as possible. All right, here we go. Whether you recollected, which he recollected, which he recollects, which I recollect, which I recollected, which you recollect, which you recollected, who recollect, who recollected, who recollects, will recollect, would have recollected, would recollect, you recollected, for the record, the records, recross examination, redirect examination, referring to, in reference, in regard, with regard, with regards, can he remember, can I remember, can you remember, could have remembered, could remember, did I remember, did you remember, do I remember, do you remember, does he remember, had remembered, have remembered, he remembers, I can't remember, I didn't remember, I don't remember, I remembered, if he remembers, if you remember, may have remembered, must have remembered. Right. Now I've got some contractions. I'm going to give you the words and then read the sentences. Here we go. They've, you've, I've, I'll, they'd, she's, I'm, theirs, we'd, we'll, we've, your, she'll, he'll, we're, we've, you'd, I'd, you'll, they'll, she'd, he'd, he's, you'd. And here are your sentences. They've gone home. We've wanted to dismiss. They've spoken before. We'd like to confer. You'll have to step down. We'd decided already. I'll think about it today. You've got to appear. You'd better speed up. We'll tell the court. Do you think they'll come? We'll get the verdict. I've told the truth. He'll go on next. They'd like to break now. He'd always worked hard. I'd like a word here. I wish she'd speak up. I hope he's ready now. She's just begun to fight. She'd better think. We're supportive of the team. He's always too late. We're very thankful. You'll see in a minute. There's the answer. You're very serious. There's no excuse. She's on the bench. She'll testify soon. He'd like to go with me. She'll repeat the answer. I'll make a ruling soon. I think I've got it. You'd never noticed? I'm not sure about it. You're going to testify. He'd asked if I'd go. There's no problem. They'd gone by then. They'll testify at 2:30 p.m. You've taken too long. He'll get immunity. I'm speaking now. We've taken the liberty. Okay. Moving into our next drill. I've got a number drill. This is going to be dates with item numbers. Here we go. Ready? September 16, MH 6907. July 31st, TX 3741. January 12th, DJ 4814. December 5th, PV 399. May 19th, TE 7951. June 4th, BX 9731. August 27th, BK 6887. February 15th, KF 3756. April 22nd, RL 3250. July 31st, EH 2662. February 3rd, NS 5832. September 3rd, TR 4751. November 5th, JM 509. October 17th, AL 2305. March 7th, AC 4802. March 9th, GL 437. November 12th, TJ 4016. October 15th, HW 5038. All right, moving into a brief review. You're going to hear you shall, should I, should you, do you, how much, I shall, we shall. All right, I'm going to read this once at 120, then again at 140, again at 160. Here we go. I shall tell you. Should you tell what you know? How much do you know? How much did you pay? How much should you pay? Should he pay the bill? Should I call you? I shall tell you how much. Should you do that? I shall pay it, but the rate is high. You shall be punished, but the punishment is fair. You shall finish your work. How much is there left? Okay, so next take will be at 140. All right, here we go. I shall tell you. Should you tell what you know? How much do you know? How much did you pay? How much should you pay? Should he pay the bill? Should I call you? I shall tell you how much. Should you do that? I shall pay it, but the rate is high. You shall be punished, but the punishment is fair. You shall finish your work. How much is there left? All right, last time at 160, here we go. I shall tell you. Should you tell what you know? How much do you know? How much did you pay? How much should you pay? Should he pay the bill? Should I call you? I shall tell you how much. Should you do that? I shall pay it, but the rate is high. You shall be punished, but the punishment is fair. You shall finish your work. How much is there left? All right. Now moving into a brief review. You're going to hear the following briefs: much, shall, should, go, but, gentleman, gentlemen. Here we go. That is a very good idea. Levi is a gentleman. The gentleman went to the boat show. We were not sure whether we should go today. Shall we go early? No, but we should be there on time. That is a good choice of words. Is he the gentleman seated to your left? How much longer shall I wait for you? He should be a good source, but if not, call the gentleman at the library. Is he a gentleman? He was rude, but I think he is a gentleman. The gentleman had great manners. His manners are usually good. Should we call the gentleman at the company? The train should be here soon to pick up the gentleman. I shall go to meet it. It should be a good thing for you to do, but it is not imperative. That is a good plan. I shall tell the gentleman in charge. You should brush your teeth. All right, now I've got multisyllabic words. Here we go. Espresso, leadership, forerunner. Capricorn, consensus, calendar. Amplitude, carbolic, disgruntle. Disinfect, hypnotic, contraband. Abutment, accustomed, dealership. Goalkeeper, gigantic, crackerjack. Dynamic, embassy, fiberboard. Crystallize, circumcise, enforcement. Ceramic, complicate, hairdresser. Centrifuge, excessive, counterpart. Ignorant, Hispanic, eccentric. Generic, ellipsis, contingent. Falsetto, cucumber, horseradish. Exercise, foolhardy, jerkwater. Yellowish, cylinder, pneumonia. Peacemaker, portfolio, psychosis. Thoughtfulness, incubation, drunkenness. Agnostic, lethargic, allergy. Abundant, indecent, abusive. Jamboree, worm goer, remorseful. Subversive, vindictive. All right. Moving into our next drill. Got some tangle tamers. Here we go. Ready? Complete reference. Funeral services pending. Contact Institute Director. Political advertisements. Resolve economic issues. Northwest corner. Southwest corridor. Sustaining veto. World peace. National security. Battle against apartheid. Uniformed personnel. Personal conflict. Deficient spending. Senior senator. Very possibly attributed. Personal observation. International inflation. No bulge profit. All right. Moving into our last drill. I'm going to do some consonant compounds. Okay, and this emphasizes initial KR, initial PR, and final VD. Here we go. The crew crossed the swollen creek. The crash created a problem. She crunched on the crumpet. The cruiser was crushed. The crepe paper was creased in the middle. Did you play cribbage at Chris's house? We prayed for an end to the pranks. The prefix precedes the noun. President Crowder put pressure on the press. The previous price levels were promoted by the store. The prophet provided a proposal. Some prosecutors protested the decision. Amy deserved to be served. He carved the turkey. Al reserved the curved table near the door. Many have lived and loved. The Joneses waved goodbye and moved away last summer. The paved street caved in after the flooding. Nate shaved off his mustache. All right. Let's move on to our literary. We're going to start off with some land description. Let me just state this. All right. Land description. I'll read this at 140. Okay, here we go. A certain lot or parcel of land situated partly in Henderson and partly in Waterbury, and on the southwesterly side of the road leading from South Waterbury to Portland, described as follows. Beginning on said road at land now or formerly of Ralph E. Martin, fenced southeasterly by said road the land of the Free Will Baptist Society, thence southerly by said society, land by a road leading to Shaker Village, then southerly to said road to land, now or formerly owned by Henry Atkins, thence northwesterly by said Atkins land, and the land of Edward Roberts, to a corner marked by a spotted tree, thence northwesterly by said Roberts land, to a stone post, thence northwesterly to said Roberts land, to a corner marked by a spotted tree, thence northeasterly to land now owned by Ralph E. Martin, to the first main road and the point of beginning, and being the Bradwell farm as called, and the Randall lot as called, containing 110 acres, more or less. All right. Now, this next set of literary material I'm going to read to you, I'll start at 120 and work my way to 160. Okay, here we go. Ready? It comes as no surprise to any of us here that we live in changing times. We are reminded of that fact daily on television, the internet, from conversation with our friends and coworkers. We know, for instance, that we no longer live a way of life. Rather, we have a lifestyle, and the kind of lifestyle we choose to live brands us either as hopelessly old-fashioned or part of the now generation. Whether we consider ourselves out of step with the times or in the forefront of modern life, we are aware of the conflicts that abound in American society today. Not only are traditional values in question, such as the importance of the family unit, but the way our complex society has developed has itself created many conflicts. Which of us can avoid at times feeling lost in the crowd, as it were? We feel overlooked and unimportant in this age that has no clear pattern. It is easy to think of this period in our history as simply the space age, but it is also been called the Cold War age, the age of civil rights, and on it goes. Let us consider then some of the contradictions of our times. In our time, man has deciphered the Dead Sea Scrolls, but is puzzled by routine U.S. government forms. We have sent spacecraft into the outer reaches of space, put a man on the moon, yet the average office worker waits for an elevator to travel even one floor. It may be safe now for a man to walk the surface of the moon, but not the streets of our own cities. We seem to be able to control the use of the nuclear bomb, but not the ordinary handgun. And medicine, of course, is a part of this age in which we live. American medicine in 2008, therefore, has its share of conflicts and critics. 100 years ago, when the physician had little more to offer his patients than patent medicines and reassurance, the American people were concerned with their right to live. Since then, American medicine has compiled a matchless record of achievement in medical science and technology. Yet today, due to those very achievements, we are debating the right to die. We can now sustain life along or long past the point where nature has given up. But we also have created new and hard questions, such as how death should be defined, who should define it, and whether or not some patients should have a right to death. The moral question of the right to die is not the only contradiction in our medical practice today, nor is it the most visible. In spite of the quality of modern healthcare, the cost is very high, and it has been caught up in the trend away from the farm to the city. It has been estimated that 73% of us now live in 272 urban centers. It is in the large cities that we find the greatest number of healthcare centers, including hospitals, medical schools, doctors, and nurses. So men and women who live in small towns and rural areas can be faced with physical barriers to care. The cost and high cost of care is a source of distress to many who wish to have available to them the highest standards of care, yet worry that they cannot afford it. Such very real concerns and problems go beyond the clinical aspects of medicine. Our leaders are trying to come to grips with the complex problems of healthcare delivery, and without a doubt, the most heated debate concerns to what degree of federal government should control the operation of the medical system in this country. Some politicians, as well as consumer rights groups, say that healthcare is too important to be left to those in the health field to run. To their way of thinking, only if the government is allowed to run the whole show can everyone be assured of high quality care at reasonable costs. Other self-styled experts say that the present system is really not a system at all, nothing more than a jumble of mom and pop corner stores. They say that this hodgepodge must be made more efficient. This gives you the scope of the ideas being set forth to cure present problems and overhaul the system of healthcare delivery in the United States today. Organized medicine has made varied responses, including flat-out opposition. In fact, it is that picture of doctors up in arms opposing any kind of change that the news media portray as the only response on the part of organized medicine. But that is not true. Doctors, the experts in medicine and medical care delivery, have responded at all times with proposals that show a real sense of compromise with the more extreme views held by some critics. These plans are set forth in good faith and must be reviewed in good faith by all interested parties. Of course, the most interested party is the American people, because it is the taxpayer who must pay the bill. And what a bill it will be, no matter whose plan is adopted. We support a plan of national health care insurance, but not one in which we work for the state rather than the patient. right. Let's move into jury charge. The subject here is fraud and deceit. So again, I'm going to start at 120 and I will work my way to 160. Okay, here we go. Ladies and gentlemen of the jury, the issues in this case are issues of fraud and deceit. Fraudulent representation or fraud, as the term is here used, may be defined as false statements of material facts in a transaction made by one party to another, made with knowledge of their falsity, or made as positive statements of fact without reference to their truth or falsity, and made with the intent that the other party shall act thereon. When such other party believes such statements and relies thereon, and is induced thereby to enter into a contract or transaction, and the statements are false and damage results to him, then such statements are fraud, which entitles the party injured to recover damages. Fraud is never presumed and must always be proved, and the burden of proof rests upon the parties asserting the fraud, the defendant in this case, to prove by a fair preponderance of the evidence, that is, the greater weight of the evidence, that he was defrauded, as claimed by him. If you find the evidence on this question evenly balanced, or that it preponderates in favor of the plaintiff, then you will find a verdict in plaintiff's favor. In order to recover on the ground of fraud or fraudulent representations, the party claiming to have been defrauded must have believed and relied upon the false statements made by the other party in the transaction. And if the party claiming fraud had knowledge of the real facts in connection with the transaction in question and relied upon his own knowledge and information and did not rely upon the statements made to him, then there is no fraud because the party asserting the fraud is not deceived. In this case, there is no fraud insofar as the contents of the agreement, Exhibit 4, is concerned, because it is admitted by the plaintiff that John Henry read the agreement, Exhibit 4, and knew the contents thereof, and he was not deceived as to what Exhibit 4 contained. The only question of fraud in this case is whether the defendants agreed to execute a promissory note for $30,000 to the plaintiff and delivered Exhibit 4 purporting to be such note, and fraudulently stated to Tyler Moore that Exhibit 4 was a promissory note for $30,000 and was the note referred to in Exhibit 4, and whether, pursuant therefore and thereto, Tyler Moore believed that said instrument to be a promissory note for $30,000. If, under the rules given you, you find and believe from the evidence that the defendant Morris, representing the defendants at the time of making the agreement of settlement, represented and stated to Tyler Moore, acting for the plaintiff in this case, that the defendant should execute to the plaintiffs a promissory note for $30,000, and that later Morris delivered Exhibit 4 to the said Tyler Moore, and then stated to him that said Exhibit 4 was a promissory note for $30,000, and was the note referred to in Exhibit 1, and you find that these statements and the making of Exhibit 4 were done for the purpose of cheating and defrauding the plaintiff as claimed, and you further find that Tyler Moore believed that said representations were true and believed that said Exhibit 4 was a promissory note on which the defendants were personally liable, and was the note referred to in Exhibit 4, and relied and acted thereon, then you will find a verdict in plaintiff's favor for $30,000, with interest added as provided for in said Exhibit 4. On the other hand, if you fail to so find from the preponderance of the evidence, or you find the evidence equally balanced on either of these issues, or if you find that Morris did not make the fraudulent representations as claimed by the plaintiff, or you find that said Exhibit 4 was in accordance with the agreement of the parties, or that the said Tyler Moore, at the time of receiving said Exhibit 4, knew the contents and terms thereof, then in either such case, you will find a verdict in defendant's favor of no cause of action. If you find a verdict in plaintiff's favor, in this case, it will be for the full amount of $30,000 with interest added, as provided for in Exhibit 4. If you find a verdict in defendant's favor, it will be the usual verdict of no cause of action. All right. Let's move into our Q&A. How are we doing on time? Good. All right. All right, so I'm going to go ahead and start with the more basic Q&A before we get into some more technical ones. Okay. All right. And this is going to start with the court. I'm just dating this so I know that we covered it. Okay. It's going to start with the court, but looks like it's going to, well, plaintiff's going to come in, but then it's going right to recross-examination with defense. Okay. Now I'm going to start this at 120, and I'll work my way to 140, and then the next one will start at 140, work our way to 160. Let me give you a word list. You're going to hear interrogatories, Mr. DeSalvo, digits, mirrors, summary, affidavit, decorator, reject, computation, computed, clarification, mathematical, Connecticut, Chamberlain, cross complaint, Darien, Hartford, amended, viable, let's see, obviously, which is OFL, and then we've got different price figures that are also in here. All right, here we go. Ready? Does that figure include the $16,098.80 on Schedule C? Yes, sir, it does. Well, then, is $59,669.44 the total loss? Yes, sir. Rather than the $75,000 plus, as alleged in your cross complaint? Yes, sir. I have nothing further at this time, Your Honor. Very well, counsel. Mr. DeSalvo, I am referring now to a document entitled Answers to Interrogatories, excuse me, dated August 15, 2013. This was the loss as originally computed, I believe. Is that correct? Yes, ma'am. I figured that in Darien, Connecticut, in about September of 2012, and I figured it from the best available records I had at the time. And although this document was apparently verified by Mr. Chamberlain, it was from information that you had furnished to him. Is that correct? Yes, ma'am. Now, obviously, there are some changes on it because the figure now, rather than $75,000 plus, it says $59,000 plus. Is that correct? Yes. Now you correct me as we go along here if I am wrong. As I understand your testimony, the $6,411.13 is still a correct figure? Yes, it is. How about the $14,353.20? Is that still a correct figure? I don't know. I have got $13,353.20. And the last 5 digits are 6 of the 7 digits are the same. I don't know whether this is a 13 or 14. It's essentially the same. Can I look at something else here? Yes, something in here. In here, I would say that either I made a mathematical error in that, or there is a mathematical error here, but the total number of mirrors claimed hasn't changed. If you were to take a minute, could you figure out whether this $13,353 is correct or the $14,353 is correct? I will say the 13,353 is correct because I see it's been corrected on here. So with respect to the loss from the mirrors cut, there has been no change between August 15, 2013 and your testimony today in the figure of $6,411.13. That's right. Yes, ma'am. And the only change in the next item, loss from mirrors sold at 20 cents a foot, is $1,000, which apparently was a mathematical error originally. Is that a correct statement? Yes, ma'am. Now then, do you have an extra copy of what you are referring to? Yes, I am looking at the summary of loss. Now the next figure, loss from sale of reject vanity mirrors on this schedule that you have just handed me, entitled Summary of Loss, shows $26,098.80. On the answers to the interrogatories on August 15, 2013, it says loss from sale of decorator mirrors. In other words, it doesn't mention vanity mirrors in that one. But are we talking about the same loss there? No, there has been a change in that. Well, I mean the same type of loss? Same type of loss, yes, ma'am. What is the change that accounts for the increase from $20,593.68 to $26,098.80? Can you explain that increase? Yes, when we left here on Wednesday with instructions to get some viable figures together, we went back to the Hartford office and we were able to determine from more complete records there that, in fact, surprisingly enough, all of the vanity mirrors had been sold. Had been? Yes, ma'am. And they had not been sold on August 15, 2013? No, ma'am. I don't think they had been. I didn't have the complete records when I was back in Darien. When these interrogatories came in for answer in August of 2013, were they sent back to Connecticut for you to answer them? I never saw them before. Well, you must have, from what you have just said. You prepared this and sent it to Mr. Chamberlain, did you not? I prepared this document in September of 2013. I am sorry, counsel. What are we referring to? Counsel, we need a clarification. I am referring to Exhibit A attached to the answers to the interrogatories with a mailing affidavit of August 15, 2013. That was an answer to interrogatory number 18, set forth in exact detail the computation of damages in the amount of $75,583.26 as alleged on page 5, line 1 of your first amended complaint. Thank you, counsel. All right. Now, we're going to move into another transcript. Looks like plaintiff is questioning right now. Here we go. I'm going to start this at 140 and I will work my way to 160. Here we go. Did you ask Detective Simmons if 250 Prada has any common signs or symbols that they use? Yes, Detective Simmons told me that 250 Prada Criminal Street gang members use several common signs or symbols in their apparel and their graffiti. He stated words such as 250 Prada, 250p, 250 neighborhood, different deviations from just 250 mostly. Did you ask Detective Simmons if one of the primary purposes of 250 Prada Criminal Street Gang was committing offenses that are enumerated in Penal Code Section 186.22e? Yes, ma'am. What did he tell you? Yes, he told me that 250 Prada Criminal Street Gang members participate in the pattern of criminal activity and have committed several of these offenses listed in 186.22. Did you ask Detective Simmons about if 250 Prada has any rivals? Yes. What did he tell you? Detective Simmons told me 250 Prada is considered to be a blood gang or a blood set, which would indicate they rival with any Crip gang, any type of Crip gang. I believe he listed with the Crips a few different Crips sets in the area. He also went on to mention a Hispanic gang. I believe it was a Compton gang. So the 250 Prada rivals with both African American and Hispanic gangs in the area. Did you ask Detective Simmons if he was familiar with the defendant, Kyle Smith? No, I don't believe that I did. Based on your participation in this investigation, the things that you reviewed, and your contact with Detective Simmons, do you have an opinion as to whether Kyle Smith is a member of 250 Prada? Yes, I do. What is that opinion? I believe that Mr. Smith is an active member of the 250 Prada Criminal Street Gang for several reasons. First, the cellular cell phone contact in his room indicated that he utilizes several of the common signs and symbols utilized by the gang. The contract was signed on August 10th of 2014, indicating that he aligns himself with the gang as early as that day. He also had paraphernalia or clothing that would indicate that he's a member of a blood gang or Prada gang. He is able to wear that clothing out to be seen by other gang members, so they'll know what type of gang that he's from. Also, due to the fact that he maintains a Facebook page, which can be accessed by utilizing the gang's name, is a fairly strong indicator. Also, the theme of the Facebook page is red. Other indicators include that he was associating himself with a member of Neighborhood Prada Criminal Street Gang just prior to the alleged offense, and the member, which is Mr. Lawson of that Criminal Street Gang, object as to the statement that Mr. Lawson is a member of 250 Prada Street Gang. I stated that he was a member of the Neighborhood Prada, ma'am, or the Neighborhood Prada Gang. No foundation sustained. Were there any other things on which you base your opinion that Mr. Smith is a member? Yes, in his association with, excuse me, during his interviews, the way that he referred to himself and Mr. Lawson, the co-defendant, or what was the co-defendant prior to the plea, is Lil G or OG. Lil G is a common street term used for little gangster, and OG is a common street name or term used for original gangster. So the two were, excuse me, Mr. Smith was referring to the two as maybe gang partners, gang allies. Objection as to that as a conclusion calls for speculation, no foundation. Well, that's an interesting objection. How do you know that? Which part? The OG. OG? Yes. I've contacted, like I said, countless gang members. During my contact with them, it's very, very common that the older or more established member of the gangs will be referred to as an OG. In speaking with them, OG, you come to the decision after they tell you that OG stands for original gangster. And just due to the fact that they're either tenured or they've established a reputation, or a lot of them have been around for so long that they're even out of the participation of criminal activity. Okay, that's good enough for me. It's also my opinion that, sorry, go ahead. Objection, no question pending. Is there anything else that you considered in your opinion that the defendant is a member of the 250 Prada gang? Yes, it's also my opinion that actually this was not necessarily that he was a member, more along the lines of the benefit of the criminal street gang for the crime is what I was going to mention. We'll get to that in a minute. Okay, how come you didn't ask what was the name of that detective down in Compton? Detective Stevens? Yes. Why didn't you ask him if he knew this guy? To me, that's so fundamental. Why wouldn't you ask that question? Well, generally speaking, young criminal street gang members will establish their association in a particular area, establish their alignments with whatever particular street gang, and they'll commonly move out of the area. I just took it for granted and assumed that Mr. Smith had moved from the area prior to Detective Stevens ever having a chance to contact him, mainly due to the fact that Mr. Smith has no criminal history, not really any type of situation where he would have been contacted by Detective Stevens. You know what they say about assumptions, right? Yes, Your Honor. Okay, go ahead. Thank you. Detective Johnson, are you familiar with a Darnell Terrell Howard with a date of birth of April 22nd of 1989 who committed a violation of Penal Code Section 211 on March 5th of 2012? Yes. How is it that you are familiar with that individual? I spoke with Detective Stevens about this particular case and this individual. And what did he tell you about that case and that individual? Detective Stevens told me Hal was a member of the 250 Criminal Prada with a moniker of Jump. Detective Stevens stated that he had reviewed the case and believed Mr. Howard to be a member of that criminal street gang. Did Detective Stevens tell you that Darnell Howard was convicted on that case under case number MR084814? I don't remember specifically, but if it's in the report written as that, then yes. Would it refresh your recollection if you looked at your report? Yes. With the court's permission? Sure, go ahead. It looks like case number MR08414. Are you familiar with a Demetrius Reynolds with the date of birth December 17th, 1968, whom on September 19th, 2010, committed a violation of Penal Code Section 12021A1? Yes. How are you familiar with that individual? Detective Stevens provided me information regarding Mr. Reynolds, stated that he is a member of 250 Prada, and believed his moniker to be Poppy. And did Detective Stevens tell you that Demetrius Reynolds was convicted on that case under case number MR76105? Yes. Based on the knowledge of this particular case, your participation in the investigation, your review of the discovery, do you have an opinion as to whether the crimes committed in this case were for the benefit of, at the direction of, or in the association with a criminal street gang? Yes, absolutely. What is your opinion? Based on my training and experience and all of the things that I have learned and come across in dealing with gang members, the number one aspect of gang subculture and gang lifestyles is respect or reputation. Acts of violence such as shooting at a person is the number one way to gain respect and or reputation by any gang member. So that Mr. Smith shot the victim not only enhances his reputation and the amount of respect that other gang members have for him, he's also enhanced the respect and reputation of 250 Prada criminal street gang members. As stated when he was interviewed by Detective Hearns, he didn't call the police because then he would be considered a snitch. In gang lifestyle, that would mean absolutely no respect whatsoever would be had by him. Also, in the interview, he says, win or lose, I still gain respect. That indicates that the most important thing for him during that time was to try to gain respect for himself. As a normal civilian would know, a person shooting another person would not mean any respect whatsoever. It would be frowned upon by society. But in a criminal street gang setting, that's the utmost way to gain respect. Thank you. Nothing further. Cross-examination. Thank you, Your Honor. Did you conduct an investigation on Mr. Stubbs' background regarding 250 Prada? Yes. Did you find anything? No, I did not. You don't have any information about Mr. Smith being jumped into the 250 Prada, do you? No. Mr. Smith didn't sign a gang card, did he? No. Are you aware of any tattoos that Mr. Smith has on him regarding the 250 Prada? No. That's it. I have no further questions. Thank you. Anything else? No, Your Honor. All right. Thank you, Deputy. Thank you, Your Honor. Anything else? The people rest as far as testimony. We would ask that exhibits number 1 and 2 be moved into evidence. No objection. All right. Thank you. They will be admitted. Affirmative evidence, counsel? No, Your Honor. People's motion? The people move that the defendant be held to answer for all crimes chargeable by the evidence. Ms. Seitz, submit on all counts except for the street terrorism count of count 3. Okay. The reason being is that I don't think that they've established that Mr. Smith was acting at the direction of, for the benefit of, or in association with a criminal street gang. This seems to be a personal fight between the victim and Mr. Smith, with the victim pursuing Mr. Smith. And Mr. Smith acted the way that he did because he was in fear that the victim was actually going to come back and kill him. It didn't have anything to do with a street gang. I don't even think that there's enough evidence to say that Mr. Smith is actually a member of a street gang. All that there is some paraphernalia found in his room and a website with a red background. Just on that, I'm going to submit. Do you wish to be heard? No, Your Honor. The court has a reasonable suspicion that the crimes charged in the complaint have been committed and the defendant has committed them. He will be held to answer for those crimes and all crimes shown by the evidence in the trial court on December 23rd at 8:30 in Department 4. And Michael, what's his bail set at? $300,000. Bail is actually set low. All right, I'll leave bail as set, but bail is set low. All right, exhibits 1 and 2 will be returned to the DA. Thank you, Your Honor. Thank you, Your Honor. So really it was the bailiff saying $300,000, but you don't really have a sign for the bailiff, so I used the court. All right, let's do a small selection for readback. Okay. All right. Let me give you a word list. You're going to hear handle, seasonal, crops, varies, conversation, concerning, business, particular, summer, spring, from time to time. In other words, melons, salary, wages, possible. That's about it. And this is going to be defense questioning. I'm going to start at 160. I'll read it again at 140 and then at 120. Okay, here we go. Your business is seasonal, is it not? Yes. What are the busiest times of the year in your particular line of business? Summer. Well, that is rather a broad term. Approximately from what month to what month? From the beginning of the summer to the end of the summer. Well, what do you consider summer? The end of spring. When is that? April 1, May 1? About the latter part of May. Would you say May 15? It all depends on the year, sir. In other words, it varies from time to time as the crops mature. Is that correct? It varies as much as 1 month in our business. Do you have a heavy fall business? Not very heavy. Do you handle melons or did you handle melons in your business? Some, yes. Quite a bit? Not very much. Now, did you have another conversation with him concerning salary or wages? Not to my knowledge, no, sir. And the 2 conversations that you have related took place in the summer? Yes, I believe it was in the summer. Did you have any conversation with him in the fall? Possibly. I might have had some then. All right, so let's do that again at 140. Your business is seasonal, is it not? Yes. What are the busiest times of the year in your particular line of business? Summer. Well, that is rather a broad term. Approximately from what month to what month? From the beginning of the summer to the end of the summer. Well, what do you consider summer? The end of spring. When is that? April 1, May 1? About the latter part of May. Would you say May 15? It all depends on the year, sir. In other words, it varies from time to time as the crops mature. Is that correct? It varies as much as 1 month in our business. Do you have a heavy fall business? Not very heavy. Do you handle melons or did you handle melons in your business? Some, yes. Quite a bit? Not very much. Now, did you have another conversation with him concerning salary or wages? Not to my knowledge, no, sir. And the 2 conversations that you have related took place in the summer? Yes, I believe it was in the summer. Did you have any conversation with him in the fall? Possibly. I might have had some then. All right, last time at 120. Here we go. Your business is seasonal, is it not? Yes. What are the busiest times of the year in your particular line of business? Summer. Well, that is rather a broad term. Approximately from what month to what month? From the beginning of the summer to the end of the summer. Well, what do you consider summer? The end of spring. When is that? April 1, May 1? About the latter part of May. Would you say May 15? It all depends on the year, sir. In other words, it varies from time to time as the crops mature. Is that correct? It varies as much as 1 month in our business. Do you still have a heavy fall business? Not very heavy. Do you handle melons or did you handle melons in your business? Some, yes. Quite a bit? Not very much. Now, did you have another conversation with him concerning salary or wages? Not to my knowledge, no, sir. And the two conversations that you have related took place in the summer? Yes, I believe it was in the summer. Did you have any conversation with him in the fall? Possibly, I might have had some then. All right, so now you just go back and choose what selection you want because we don't really have any students in the live class, and go back and compare what I said to what you have and see how you do. Okay, and the only difference was the last take at 120. I said down below, I said, I put in on accident the word still, but when you go to listen to that, like if you want to read your notes from 120, then listen to the last selection and you'll hear it. Okay, so it's just the word still. All right, so that concludes our Mid Speeds live class. Have a wonderful day.